Hello and welcome to Property Money Trees, Maximising Property Values, the once a month show where I break down the steps of how to recognise, enhance and then extract the values in property in order to create wealth. Would you like to find out how you can benefit from the steps of maximising property values? This is even if you don't own a property yet or have a deposit. If that's a yes, then you're in the right place to find out. My name is Patricia Faber, and although many know me for my work as a solicitor, on this show you will be getting the benefit of my 30 plus years worth of experience of maximising property values, experience which has given me a net worth in millions. So who might benefit from listening to this show? Literally anyone with an interest in creating property wealth. Welcome back. I sincerely hope that you guys who've been listening to me have also been reading about other people's views on the Renters' Rights Bill, because this is a generational legislation that's coming in, and like I keep saying, no one should sleepwalk into the new era. Anyway, let's get on to the next chapter that I'm going to be reading. Actually, not quite a chapter, it's a sub-chapter. And it's headed, When Might the Proposed Law Not Apply? The new law will only apply to assured tenancies. Assured tenancies are essentially residential tenancies, A, that are for a dwelling let to at least one individual, so that means not to a company or organisation. B, where the tenant will live in the dwelling as their only or principal home. And C, where the tenancy is not an excluded tenancy. Examples of excluded tenancies are 1. Six-figure rentals, so that would be £100,000 or more per year. 2. Very low rent tenancies of less than £1,000 a year in London or £250 elsewhere. 3. Business tenancies under Part 2 of the Landlord and Tenant Act 1954. 4. Licensed alcohol selling premises tenancies. 5. Tenancies of premises that come with more than 2 acres of agricultural land. 6. Student lettings by certain institutions and bodies. 7. True holiday accommodation licences. 8. Lodger situations. 9. Crown and some local authority tenancies. And 10. Once the bill becomes law, leases of 21 plus years will also be excluded from being assured tenancies. An excellent resolution to the ground rent problem that blighted many leasehold properties and made them unmortgageable. In addition, leases of more than 7 years but less than 21 years, or contracts for these, entered into within 2 months of the bill becoming law will also be excluded. As I only make suggestions but give no advice in this book, I shall say no more. Then the proper chapter 1. Assured shorthold tenancies, ASTs and fixed term tenancies are being abolished. From the day that the bill becomes law, all relevant tenancies, except those where valid Section 21 notices exist, and only for up to 3 months from then, will become periodic assured tenancies. Assured tenancies to which the new law will apply will be tenancies characterised by being for up to 28 days. For example, weekly or fortnightly, or monthly, with rents being payable for the same periods as the tenancies. Things to note. The right to obtain possession with no questions asked, no fault evictions, will no longer exist. Court action for valid Section 21 notices served before the new law comes into force will need to be started within 3 months of the bill becoming law if the tenant doesn't leave voluntarily and a court order for possession is therefore required. The right to obtain possession via the accelerated procedure will no longer be available where it might have been before. Rent periods must be the same throughout the tenancy, but the first rent period can be different from the other periods and can be for less than 28 days, so rent dates can still be set at the beginning of the tenancies. Advance rent payments will no longer be allowed, except for the first rent, a maximum of 1 month, which can only be received after the tenancy agreement is signed, albeit before the tenant moves in. Rent payment dates should therefore not be expressed to be before the period, if it's a month, a week, etc. Although it looks like it can be expressed to be payable on the first day of the period. I don't see anything, though, to stop the deposit from being demanded and paid before the tenancy is entered into. If rent has been paid in advance, presumably before the bill becomes law, and the tenant terminates the tenancy before the paid rent is used up, the landlord must refund any rent for periods after the termination. Tenants will still be liable for council tax where they were liable for it with longer fixed term tenancies. And I shall stop there, and next month I shall look at chapter 2, where it says all relevant tenancies will be periodic, and also chapter 3, which deals with superior leases and licenses. So that's what we've got next month, and then the following month I'll look at possession grounds. See you next month.